Assalamualaikum warahmatullahi wabarakatuh and good morning everyone. My name is Nursyada binti Abdul Razak, metric number 26431, and today I will explain to you about the introduction of the stamp duty. Firstly, let me tell you a brief history of stamp duty. So, where does the stamp duty come from? Actually, stamp duty is originated from England in 1694. At that time, they are actually introduced as a transaction tax and were imposed on a limited range of goods. However, as the time flies, stamp duty has evolved and the range of products covered by this tax has expanded to all kinds of weird and wonderful products such as hats, gloves, lottery tickets, newspaper, pamphlets, advertisements, perfumes, and hair powder. And then, around 1702 or 1703, England has successfully collected a total profits of GBP 91,206, which is generated from the stamp duty, and that amount is actually equivalent to 54.71 million ringgit Malaysia today. So, because of the ability of stamp duty that were able to raise funds for the government, it has become an important foundation of stamp duty until today. Now, you may ask, how is the stamp duty introduced in Malaysia? Okay, stamp duties were first legislated in Malaysia in 1949. Due to England's attempt in exporting laws and taxation, the British common law has become one of the two pillars in Malaysia's justice system, and stamp duties are one of the elements adopted from the colonial process. In Malaysia, stamp duties are imposed on the instruments as specified in the first schedule of Stamp Act 1949. Unlike England, the stamp duties are not applicable on transactions. With effect from 1 October 1989, the Act is applicable throughout Malaysia, where the duty imposed may be divided into two types, which are fixed duty and ad valorem duty. To briefly explain, regarding the types of duties, a fixed duty is a duty that is fixed at a sum which does not differ with the value of transaction, while the ad valorem duty is a duty that varies depending on the value of the transaction as specified in the instruments. Next, we will look into the administrative organization of the stamp duty. So, basically, there were several parties that were highly responsible in the administration of the stamp duty. They are called as the collectors, which consists of the collector and deputy collector of stamp duty. Under the Section 134 subsection 1 of Income Tax 1967, it is deemed that the Director General of Inland Revenue shall be the collector of the stamp duty. On the other hand, a number of deputy collector of stamp duties may be appointed by the Ministry of Finance as he thinks fit. So, what is the power of the collectors? Section 3A Stamp Act has listed 5 powers of the collectors as shown here. First, the collector may issue a written notice to any person to produce any instruments in order to ascertain whether it is chargeable with duty under the Stamp Act and to ascertain whether the payment of duty has been settled or not. Second, they have a full and free access on all lands, buildings, places, books and documents where the collector may make extract from or copies of any books or documents in case where he considers that it is necessary and relevant to ascertain the market value of a property or to ascertain any facts or to inspect the books and documents. Third, they have a power to possess such books and documents which, depending on the situation where the inspection or copying of such books and documents cannot reasonably be performed, or where the books and documents might be destroyed or concealed, or it might be required as evidence in any proceedings. Next, they may authorize any valuer employed by the government, whether it is private or public, to exercise any of the powers conferred upon the collector by this section, such as to ascertain the market value of any property. Lastly, if any person obstructs or hinders the collector or any valuer duly authorized by the collector from exercising their powers, that person may be charged to a fine amounting less than 250 ringgit, and this also applies to the person who refuses or fails to comply with any notice or direction given by the collector. Next, we will look into the comparative yield of stamp duty in relation to other taxes. So, in this part, I will explain to you the differences between the stamp duty with income tax, RPGT, and SST in terms of definition, basis of charge, chargeable person, and rates. So, for additional information, stamp duty, income tax, and RPGT are a direct tax, while SST is an indirect tax. Now, let us look into a brief definition of the taxes that I have mentioned earlier. Firstly, we have stamp duties. Stamp duty is a tax on stamping legal documents or instruments. Second, we have income tax. So, income tax is a tax on income derived from Malaysia or received in Malaysia. Third, we have RPGT. RPGT is a tax on gain or profits derived from disposal of Malaysian real properties. And lastly, we have SST, which is a single stage tax that is charged on manufacturer or importer and service provider. Next, we have the basis of charge. So we want to know what does these taxes are imposed to. Okay, firstly we have stamp duty. Okay, stamp duty is charged on the amount specified in the instruments or legal documents. Income tax is charged on income that is derived from or received in Malaysia. RPGT is charged on the chargeable gains from disposal of real properties in Malaysia, and lastly, SST is charged on the taxable goods manufactured or imported to Malaysia and on services rendered in Malaysia. Next, we have chargeable person. Okay, so for stamp duty is chargeable on the person that is payable based on the types of instruments as listed in the third schedule of the Stamp Act. Income tax is chargeable on the individual, business, and corporation that has derived or received their income in Malaysia. The chargeable person for RPGT is a company, partnership, body of person, and corporation that has disposed their real property in Malaysia. And lastly, for SST, we have two, which are the sales and service tax. So, for sales tax, the chargeable person is the manufacturer or importer of the products, while the service tax is chargeable on the consumers and the service rendered. Lastly, we will look at the rates of these taxes. So, the rates for stamp duty is between 1% to 4%. Income tax is between 0% to 30%. And then 5% to 30% for RPGT, and lastly 5% to 10% for sales tax, while the service tax rate is fixed at 6%. Structure of Stamp Ordinance 1949. So actually, they are first enacted in 1964 and were revised in 1989. It consists of 10 parts, which consists of preliminary, provisions applicable to instruments generally, provisions applicable to particular instruments, liability for payments of duty, adjudication as to stamps, the time of stamping instruments, instruments not duly stamped, allowance for spoiled stamp, offences and penalties, and lastly miscellaneous part. The Stamp Ordinance consists of 52 amendments where more than 80 sections are amended and added, which the latest amendments takes place in 2014. So that's all from me. Next, we will look into the general principle of stamp duty that will be presented by Nurul Najwa and Ilya Shahira.
Assalamualaikum and hi. My name is Nur Najwa binti Zalan Jeffrey. My matric number is 264404. Lilia and I are going to present the principle of stamp duty part. To summarize, the principle of stamp duty can be divided into two, which are general principle and valuation of duty. The general principle consists of the doctrine of form and substances, stamp duty on instrument not transaction, the leading and principal object, the contingency principle, and the separate and distinct rules matter. Whereas for valuation of duty, it consists of rates of stamp duty and valuation of duty. General principle. Okay, the first one is the doctrine of form and substances. The text doctrine of substances over form can be referred to the need to examine the substances of the agreement or document or instrument rather than its form. The scope and amount of stamp duty levied on the instrument can be determined by the examination of the true and real meaning of the instrument, which is the substances, and not the description of the instrument, which is the form. The substances or form is applied on the stamp duty in the classification of the instrument. Okay, the classification of the instrument can be determined by the substances of the instrument as interpreted by the right and obligation created rather than its form. Okay. The substances over form usually invoked by court in cases where the taxpayer planned a scheme of transactional relationship in a document solely to gain a tax benefit. Okay. If the tax motivation outweighs the transaction business purpose and profit goal, okay, the court will decide that the form, which is the written contract, does not reflect accurately the substances of the agreement, thus the intended tax benefit will be denied. Okay, the first case related to the doctrine of substances over form is the case of Eastern National Omnibus Company versus Inland Revenue Commissioner 1939. Okay, the issue is whether the agreement is payable to stamp duty. Okay, this case is about a bus company. Okay, this bus company service is selling buses to other company. Okay, after that, they withdraw their services for that particular area. In return, they receive a monetary payment, thus occur an agreement. Okay, after looking at the substances of the agreement, it was held that the agreement is for sales of goodwill, thus the agreement is payable to ad valorem duty. The second case related to the tax doctrine of substances over form is the case of Malayan Palm Oil Bulking Company Limited versus Commissioner of Stamp Singapore 1940. The issue is whether the stamp duty assessment adopted was correct. In this case, a document described as a co-license was presented to the Commissioner of Stamp for stamping purpose and a stamp fee of 5 Singapore dollar was tendered. The Commissioner of Stamp has an opinion that the document amounted to a lease and agreement under seal. Thus, the Commissioner of Stamp certified that the proper stamp duty is 101 Singapore dollar, basing his assessment on the ground that the lease was for a period exceeding 3 years at annual rent of 6,000 Singapore dollar and certain charges of pumping oil. The document was stated to be a supplemental of two license, where each license with a rent of 6,000 Singapore dollar. The license stated other consideration for the rent is about the grantors granted three things. Okay, the first one is full and exclusive right and authority to use the storage tank for sole purpose of receiving, storing and delivering by palm oil only produced by the licensee estate and purchased by them. The second one is full but not exclusive right and authority to use and benefit from the grantor's machine and work in the grantor's premise and adjoining premise. And the last one is the right and liberty for the licensee to enter upon the grantor's said premise and adjoining premise. Conclusion: it was held that on the true construction of the document or substances of the document, it was a lease. Thus, the assessment adopted by the Commissioner was correct. The last case related to the tax doctrine of substances over form is the case of Tay Kiok Yap versus Commissioner of Stamp, Singapore, 1966. The issue is whether the deed of agreement chargeable to stamp duty. In this case, on the death of the deceased person, the letter of administration had been granted to the deceased principal wife and his son. Subsequently, a claim was made by Tan Lian Chow as a lawful widow of the deceased. The High Court found that she was the lawful widow of the deceased and ordered the letter of administration to be granted to her and the other widow and son. After that, the parties entered into a deed of agreement where Tan Lian Chow received 220,000 Singapore dollar in consideration of renouncing all her right to the estate. The deed was presented for assessment of stamp duty and Commissioner of Stamp certified that the deed was chargeable with ad valorem duty. After that, the appellant was dissatisfied with the assessment and appealed to the court. Conclusion: it was held that the deed of agreement was a conveyance on sales for property within the meaning of stamp ordinance, therefore attracted to ad valorem duty. Thus, the deed of agreement was chargeable with stamp duty. Stamp duty on instrument, not transaction. Okay, what is an instrument? Instrument can be defined as any written document. Stamp duty. Okay, stamp duty is imposed on the instrument, not the transaction. Okay, all written instrument is specified in the first schedule of Stamp Act 1949. According to Stamp Act 1949, Section 4 provided that all instruments in the first schedule should be chargeable with stamp duty in that schedule, and generally, no duty is payable if the transaction can be effected without creating an instrument of transfer. The related case for stamp duty on instrument not transaction is the case of Lim Tek Lee versus the Commissioner of Stamp Duty 1956. This case is about several individuals trading under the firm name of Lim Tek Lee was registered as an owner of trademark. Then, a partner retired. Okay. After the retirement of the partner, the remaining members of the firm applied for the trademark registration under their names. Okay. In the spot of the application, they provide an instrument. Okay. This instrument is related to the transfer of the retiring partner's share in the partnership asset to the continuing partners. Okay. The instrument is stamped as a receipt with 6 cents. Then the commissioner adjudged it to be stamped with ad valorem duty, and this was affirmed by the High Court. Okay. It was held that the instrument was not a mere receipt, but a transfer of the retiring partner's share in the partnership asset to the continuing partner, and it was a conveyance for sale in equity. Therefore, it was chargeable with ad valorem duty. In conclusion, the Stamp Act taxes on instrument, not transaction. The next case related to stamp duty on instrument, not transaction, is the case of BASF Service Sdn Bhd versus Pemungut Duty Stamp 2010. The issue is whether the stamp duty imposed on instrument, not transaction. This case is about an appellant purchased a piece of property from Perbadanan Kemajuan Negeri Pahang and pursuant an agreement. This agreement comprises of 3 types of payment to be made to PKNP, which are the purchase price of 84,593,372, a development fee of 24,794,609, and infrastructure fee of 61,257,269. The total was 170,645,250. In the transfer form which was sent for adjudication, the appellant stated the purchase price but omitted the development fee and the infrastructure fee. After receiving the transfer form, the respondent assessed the stamp duty on the total of 170,645,250, which this is under item 32 clause A of the first schedule of Stamp Act 1949. After that, the appellant felt dissatisfied with the stamp duty imposed and filed a notice of appeal to the High Court. The High Court concluded that the stamp duty was payable on the purchase price and development fee but excluded the infrastructure fee. Then, the respondent felt dissatisfied. The respondent appealed to the Court of Appeal. The Court of Appeal held that it was payable to the total of the contractual. Hence, the appellant appealed again. It was held by the Federal Court that the agreement entered between both parties is inclusive of the disposal of the land and the carrying out of the infrastructure work. Thus, the infrastructure fees are part of the consideration of the property, therefore chargeable to ad valorem duty. In conclusion, the stamp duty is imposed on the instrument, not transaction. Leading and principal object. According to Stamp Act 1949, Section 4, Subsection 3 provided that in the event where several instruments involved in completing a transaction, the principal instrument shall be chargeable. Meanwhile, the subsidiary should be chargeable at 10 ringgit per instrument. Okay, if the principal instrument is exempted, the subsidiary also follow exempted. The case related to leading and principal object is the case of Chia Chun Gan and others versus Registrar of Title Kedah 1973. The issue is whether the documents are properly stamped. In this case, there are 7 appellants. These 7 appellants were the co-proprietors of a piece of land. Then they entered into a partition agreement and effected a cross-transfer of a land by means of 3 memorandum of transfer on subdivision for the land being granted. Next, the solicitor of the appellant requested the collector to value the three memorandums separately. After that, the solicitor proceed having the greater value of the memorandum which affected the property value stamped with ad valorem and the subsidiary stamped with 50 cent stamp. Then they presented the stamp memorandum for registration. The collector accept the principal which is stamped with ad valorem but rejected the subsidiary on the ground that it was not properly stamped. Okay, so the appellant appealed. The appeal made to the High Court were dismissed. The appeal made to the Federal Court were argued. It was argued that this case is a case of exchange within the scope of Section 4, subsection 3 of Stamp Act 1949, which read with Item 32 and Item 43 of the first schedule. Conclusion: Federal Court allowed the appeal. It was held that this case is a case of exchange related to Item 43 of the first schedule. Since the ad valorem duty was paid on the greater value of the memorandum, thus the subsidiary or the other two memorandum were properly stamped. The separate and distinct rules method. According to Stamp Act 1949, Section 6, Clause A provided that instruments related to several distinct matters should be separately charged. Section 6, Clause B provided that instruments made for any consideration which is chargeable with ad valorem duty and also for any further consideration should be separately charged. Okay, overall, Section 6 is about distinct matter including separate consideration should be separately charged.
Hi, my name is Ilya Shairah and the metric number is 264398. So I will continue with the last general principle, which is contingency principle. So an instrument will be subject to stamp duty by reference to its effect and to the circumstances as they exist at the time when it is executed. However, if at the time the relevant instrument is executed, it is not possible to determine the consideration, the Stamp Office will apply the contingency principle. Under this principle, all contingencies are ignored, and if the relevant instrument set a maximum limit for the consideration, stamp duty will be payable on this amount. So, in circumstances where no maximum amount is stated but a minimum amount is set, then that figure will be taken as the consideration payable. Where the consideration is expressed as a formula or by reference to a benchmark figure, relevant case law will in most cases indicate the manner in which the Stamp Office might apply to the contingency principle. Focusing on Malaysia, the contingency principle is based on the Stamp Duty Act. So the first one is the stamp duties are imposed on instrument and not transaction. The second one is the stamp duty imposed to legal, commercial, and financial instrument. The third one is the instrument that executed within Malaysia must be stamped within 30 days of its execution. So the fourth, the instrument that executed outside Malaysia must be stamped within 30 days after it has been received in Malaysia. So the last one is the duty calculated based on the property price of the contract of sale or the higher price of the market value. So next, we move to the other subtopic, which is valuation of duty. In the subtopic, we have two things to discuss, which is the first one is the rates of the stamp duty, and the second one is the valuation for the duty. So the rates of stamp duty is mentioned in the first schedule item 32A of Stamp Act 1949. So in 2018, the first 100,000 value of the property will be charged on 1% of rates, and the duty payable is 1,000. The next 400,000 value of the property will be charged on 2%. So the duty payable is 8,000. And the excess of 500,000 will be charged on 3%. In 2019, same, first 100,000 will be charged on 1%, next 400,000 will be charged on 2%, but the difference is here, the next 500,000 will be charged on 3% with effect 1 January 2019. The property that above 1 million will be charged on 4%. Okay, now let's see the example of the computation stamp duty payable. Mr. Tan disposed a residential house in Bangsa to Ali for 1,500,000 on 14 February 2020. So the stamp duty payable to the stamp office would be computed as follows. The first 100,000 will be charged on 1%, next 400,000 will be charged on 2%, next 500,000 will be charged on 3%. So the balance is 500,000 more will be charged on 4%. So the duty payable is 44,000. Alright, the second thing is valuation for duty. Okay, to access the value of the property, you must compare the value of consideration or market value of the property, whichever is greater. Section 12A of Stamp Act 1949 provides that an instrument is chargeable with duty under item 32A of the first schedule. The date for determining the market value of any property being transferred, settled, or gifted shall be the first one. In the case of settlement or gift, we should take the market value at the date of execution. Second, in the case of transfer implementing a sale under duly stamped agreement of sales and purchase, we should take the market value at the date of execution. Third, in the case of transfer of property granted by statutory body, local authority, or any cooperative society that registered under laws relating cooperative society, we should take the market value at the date when the final terms of transfer communicated to the transferee. Subsequent resale of that property, we should take the date of consent by statutory body or local authority or board cooperative society for that resale. Fourth, in the case of transfer under duly stamped sale and purchase agreement, where the financial agreement made accordance with Sharia, we should take the market value at the date of execution. Or any other case, we should take that market value at the date of execution. So there are two cases that related with this subtopic, which is the first one is Chin Choi and others versus the collector of stamp duty. So the issue of this case is whether the duty payable should be based on market value of the date of the sale and purchase agreement or market value when the instrument of the transfer was executed. So the case starts when the property was agreed to be sold by a sale and purchase agreement on 30 October 1971 for the purchase price of $49,000. The memorandum of transfer was executed on 26 June 1973. Then, the collector of stamp duty assessed the market value of the property as at 26 June 1973 at $65,000 and assessed the duty accordingly. the appellant is dissatisfied and appeal to the High Court. So, the federal court against the assessment, but the appeals were dismissed. On further appeal on the Privy Council, it was held that the assessment of the duty made pursuant to Section 12A of the Stamp Act and had been correctly done by the collector. Next, case collector of stamp duty versus Eng Fah In and others. In this case, the first respondent sold land in Temeloh, Pahang to the other respondent for $1,938 per acre. Then, the memorandum of the transfer was sent to the collector of stamp duty for stamping. The collector then refused to accept the consideration stated in the transfer as the value of the land. He then sent it to the valuation officer in Temeloh for an inquiry and report. The valuation officer gave the value of the land as $12,000 per acre. So, following this report, the collector of stamp duty decided that the ad valorem duty payable should be based on $122,600 and the stamp duty was payable $1,452. So, the respondent asked the collector to state a case for the opinion of the High Court. So, the High Court judged that the value of the land was only $3,000 per acre and the duty due was accordingly to be reduced and the excess to be refunded. Transfer of real property. With effect from 1 January 2008, the taxpayer may apply for an instrument of transfer of landed property to be stamped based on a value of the property submitted by him, meaning that the assessment can be made by private valuer but need to include bank guarantee. So the bank guarantee is computed as A minus B. What is A? A is Y times 100 and divided by 65. What is Y then? Y is market value by private valuer or the consideration. What is B? B is the amount of stamp duty based on private valuation. Incorrect estimate penalty. The taxpayer must ensure the duty paid reflect to the actual market value. To avoid loss of revenue to the government, Section 36B subsection 6 states that if any event the additional stamp duty exceeds 30% of the actual stamp duty, 10% penalty will be imposed on the excess. Referring to the previous slide, the actual stamp duty computed by government valuer is A. Initial duty is B, and then the bank guarantee amount, and then minus, you get the additional stamp duty. So, if the additional stamp duty is exceed 30% of the A, the excess will be penalty on 10%. Additional assessment. When the duty payable value from government is higher than private valuation, within 3 months after payment initial duty, the collector will issue additional assessment to recoup up additional stamp duty. So the taxpayer must pay additional duty within 30 days after the notice. If the taxpayer fail to pay, the collector will call upon bank guarantee. If the bank guarantee is sufficient, duty payable is settled. But if the bank guarantee is insufficient, the remaining unpaid duty will be increased by 10%.
My name is Pratana, entry number 264882. Today I am going to continue the presentation about the instrument not duly stamped. Section 51, subsection 1 stated that every person having by law or consent of parties authority to receive evidence and every person in charge of public office except an officer of police before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions shall, if it appears to him that such instrument is not duly stamped, impound the same. To summarize it, every person with the authority to accept evidence under the law or with the consent of the parties, as well as every person in charge of public office, excluding an officers of the police, should impound the same. Section 51, subsection 2 stated that for that purpose every such person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp of the value and description required by the law in force in Malaysia when such instrument was executed or first executed, provided that nothing herein contained shall be deemed to require any magistrate or judge to examine or impound if he does not think fit to do so any instrument coming before him in the course of any criminal proceeding. In the case of judge of the High Court, the duty examining and impounding any instrument under this section shall be performed by the registrar. To summarize it, Malaysian law stated that an instrument must be stamped with a stamp of the value and description required by the Malaysian law when such instrument was executed, provided that nothing herein deemed to require any magistrate or judge to examine or impound if he does not think fit to. The duty of examining and impounding any instrument under this section shall be performed by the registrar. Okay, for this slide, I already explained it before, so I'm going to move on to the next slide. M. Manohar Kamath versus M. Ram Mohan Kamath and Anor. The fact is, the debtor want to produce that document to prove his possession of the litigation property, so he filed a petition for this. So the court enforced found that the document was not properly stamped and impounded documents to instruct to pay the fine. Okay, now I'm going to explain about the impact on not duly stamped. Unstamped instrument will not be admissible as evidence in the court, barring some exceptional circumstance, and also it cannot be registered act upon authenticated by any person or public officer. Next case is Okbile Golf Property Sdn Bhd versus Univille Sdn Bhd. Okay, the defendant company, which is refers to is a landlord of a piece of land. Since he did not pay the loan from Kuwait Bank on time, Kuwait Bank applied for a cargo to be the manager of to deal specifically with this property so that it could repay the loan from Kuwait Bank. However, company P claims to be a tenant of the cargo place. The lease was signed with D before Kuwait Bank appointed a manager. Therefore, the cargo space must be leased to B, not to others. The manager's defense was that because the lease did not pay stamp duty, the lease cannot be accepted as evidence by the court under Section 52, subsection 1 of the Stamp Act. The lease is fictitious and not genuine lease. But this restriction is not absolute. According to Section 52, subsection 1A, as long as pay the stamp duty and fines later, the document can be used evidence in the court. The court held that the lease was false. The lease is fictitious lease between P and D. The intention is to receive the manager of Kuwait Bank for not successfully handling this property. Instruments impound, how deal with. When the person impounding an instrument under Section 51 is authorized to accept evidence by law or by the agreement of the parties and accept the instrument in evidence in exchange for payment of duty and penalty. He should, as soon as possible, deliver such instrument to the collector together with the amount of the duty and penalty, if any, paid in respect thereof. The collector will stamp the instrument and return it to the person who submitted it to him in accordance with Section 43 or 47A. However, if the tax and penalty are not paid, the collector shall retain the instrument. Agreement evidence by letter, not stamp. A contract or agreement can be effected by correspondence consists of two or more letters, and any one of the letter bear the proper stamp in constraint or agreement shall be deemed to be duly stamped. It shall be lawful for the collector, on being satisfied that the omission to have the letter or letter stamp did not arise any intention to evade the payment of stamp duty. On stamping any letter under this section, the collector shall write or cause the return and the letter the word duly stamped and shall add his signature or initial thereto, and the day, month, and year on which the letter was stamped. After a letter stamp, all the letter forming together the agreement may be used in evidence to prove the agreement state.
Good morning everyone. I am Udayadarshini Suresh Kumar from Group 7. My metric number 264638. I am going to continue today's presentation on allowance for spoiled stamp. Without further delay, let's get into the topic. Allowances for spoiled stamp. As provided in Section 57, the stamp on any paper inadvertently and undesignedly spoiled or obliterated or by any means rendered unfit for the purpose intended, before the paper bears the signature of any person or any instrument written thereon is executed by any party. The collector may on application make allowance for impressed spoiled stamps under some condition. If the stamp on any paper gets spoiled, for example by error in writing or any other means, document on which is written but not signed, promissory note which is not being used in any manner, bills of exchange signed but not accepted, instrument executed which has later become void. Next, in Section 58 provides for misuse of stamp allowances. Misuse of stamp allowances is relevant when a person is inadvertently using an instrument that charges more stamp than necessary. Additionally, can occur when using a stamp for an instrument that is not related to the task inadvertently. The collector may cancel and allow as spoiled the stamp so misuse upon application made within 12 months after the date of the instrument, or if it is not dated, within 12 months after the execution thereof by the person by whom it was first or alone executed, and upon the instrument, if liable to duty, being stamped with the proper duty. With the support of Section 57 and 58, Section 59 was issued indicating that in any circumstances where provisions are made for pampering, unused or improper stamps are used. Therefore, the collector will convert it to the same monetary value. Alright, this slide regarding the conditions for granting allowance. Section 15A subsection 2 of Stamp Act provides relief from stamp duty in the case of a transfer of property to achieve greater efficiency in operation between associated company on any instrument if the collector of stamp duties is satisfied with these following conditions. Firstly, the effect of the transaction is to transfer a beneficial interest in a property from one company with limited liability to another company, and the companies are associated. In a simple word, one company is the beneficial owner of at least 90% of the issue share capital of the other. Next, a third company with a limited liability is the beneficial owner of not less than 90% of the issue share capital of each of the companies. Lastly, the transferee company must be the incorporated in Malaysia. Time limit for claims. There is a time limit in making a claim in this stamp duty. Firstly, it must be within 4 years from the date revenue stamped the instrument, which is on the date of the stamp certificate. However, if an individual has claimed a refund of stamp duty paid from certain instrument combined with a building agreement for a dwelling house or apartment, or certain leases combined with a building agreement for a dwelling house or apartment, the claim needs to be done within 3 years of the date on the stamp certificate. Now, let's move on to the last subtopic, penalties for late stamping. Under Section 47A, subsection 2, any instrument that is not stamped within the permitted period, a penalty will be imposed depending on the circumstances. If you look at this diagram, you can see that penalty imposed for the late stamping is varies. 25 ringgit or 5% of the amount for the deficient duty, whichever sum be the greater if the instrument is stamped within 3 months after the time for stamping. 50 ringgit or 10% of the amount of the deficient duty, whichever sum be the greater, if the instrument is stamped later than 3 months but not later than 6 months after the time for stamping. Lastly, 100 ringgit or 20% of the amount of the deficient duty, whichever sum be the greater in any other case. The longer it takes to make a payment, the higher the amount of the fine imposed. In other words, if it is not stamped within the period stipulated, a penalty will be imposed based on the period of delay. Stamping of instrument after execution. All instruments chargeable to stamp duty and executed by any person in Malaysia shall be stamped before or at the time of execution or within 30 days of its execution. However, if the instrument outside Malaysia effects a transfer immovable property situated in Malaysia, shall not take effect unless it is stamped within 30 days after it has been first received in Malaysia. If it is stamped after the expiration of 30 days after receiving in Malaysia, a penalty will be imposed. Now, we have come to the end of the presentation. As a conclusion, stamp duty is a tax on legal, commercial and financial instruments such as sale, transfer, home loan or loan agreement. The stamp duty is not a transaction but is an instrument. In the simple word, it is defined as any written document and in general. These are due to it being chargeable on instrument but not on transaction. Moreover, they are instruments which are not duly stamped. It consists of 3 situations such as stamp not paid at all, insufficient stamp and stamp have not been properly cancelled. In addition, there is allowance for spoiled stamp which is stated under Section 57 as condition for granting the allowance and time limit to make a claim for the allowance. Lastly, an instrument may be stamped within 30 days of its execution if it has been executed within Malaysia, or within 30 days after it has been first received in Malaysia if it has been executed outside Malaysia. If they fail to stamp within the period stipulated, penalty will be imposed based on the period of delay. Well, that's all from us. Thank you very much.